Welcome, everyone. Thanks so much for joining us. My name's Dr. Amanda Cohn. I'm a Greens MP in the New South Wales State Parliament, and I'll be emceeing tonight a truly fantastic panel of experts for a really important discussion about the new laws that have been passed in the federal parliament. Before I continue, I'll acknowledge that I'm zooming in tonight from Gadigal land that was stolen and never ceded. Of course, no matter where you're zooming in from across Australia, all of this always was and always will be Aboriginal land. And I think especially this week, especially given so many of us were acknowledging Invasion Day or Survival Day yesterday, the conversation we're having about our rights and opportunities to express our democratic freedoms in Australia are, of course, so important in the ongoing struggle for First Nations justice, and particularly talking about campaigns against racism. Of course, this impacts First Nations people most of all. We have an absolutely fantastic panel tonight to discuss this issue. We've got my fantastic colleagues, Federal Greens Senators for New South Wales, Mehreen Faruqi and David Shoebridge. We're joined by Timothy Roberts from the New South Wales Council for Civil Liberties and Greg Burns SC from the Australian Lawyers Alliance. I think the fact that we had over 1,000 people register for tonight's event shows just how timely this discussion is. Certainly from my own perspective, watching these laws pass so quickly means that people have so many questions about what they mean, and certainly the general public has not been brought on board with what this actually means. So thank you so much, David and Mehreen, for hosting such a timely discussion. Just a little bit of housekeeping before we get started. There will be time for questions towards the end of the event, but please use the Q&A function in Zoom for that. So rather than put your questions in the chat so we don't miss them, please put them in the Q&A, and there's an opportunity to ask your questions anonymously as well, if you like, and I'll be putting some of those questions to our panelists towards the end of the event. I also wanted to let you know that we're recording tonight's event, and that will be uploaded publicly. So if you don't want to appear as part of that recording, make sure that you've got your camera switched off as well. To kick us off, it's my absolute pleasure to introduce my colleague, Dr. Mehreen Faruqi, Deputy Leader of the Australian Greens and the Greens spokesperson for anti-racism. Mehreen has been an absolutely staunch campaigner against racism for many decades, and Mehreen is going to talk us through the political context for the laws that were just introduced. Mehreen.
Hey, thanks, Amanda. Hi, everyone. Thank you for joining us this evening. I do wish it was under better circumstances, but here we are. I know that many of you will have followed along as the Combating Anti-Semitism, Hate and Extremism Bill 2026 was published, introduced, and passed in a matter of days. And really, the sham process that the government undertook on this bill was as appalling as the bill itself. The process itself was opaque and rushed, and the bill divisive and dangerous. I mean, there wasn't even a pretense of consultation for some of the most extreme changes to our criminal laws. Following the horrific anti-Semitic attack in Bondi Beach in December, it sadly didn't take long for Labour, Liberals, and One Nation to try and link this with the movement for a free Palestine. This is despite the fact that the vile, hateful murderers had no connection to Palestine, were not Palestinian, and had no link that we know of to the Palestine Solidarity Movement. Really, in what should have been a time for solidarity and kindness, this tragedy has been politicized and weaponized to clamp down on, to demonize, and to silence a movement for peace and justice. From the very beginning, the draft bill was quickly exposed to be flawed and really fraught. It was clear that these laws were designed to protect some and not others. And this rushed legislation fundamentally divides people by religion or prevents people from critiquing governments and their human rights abuses. With every hour that passed, our teams, legal experts, community leaders, faith leaders, and many organizations were finding new problems, red flags, and more threats to basic civil, political, and human rights. And it was pretty clear that the bill, apart from the gun law reform, was really bad. It was designed to threaten a right to protest and silence supporters of Palestine and those who speak out against Israel's genocide in Gaza. So the Greens made clear that we would be opposing all but the gun law reform part of this omnibus bill. That resulted in the very broadly drafted racial vilification section being canned, which would have had if you can believe it, an even more draconian influence than what we now have. But in a last minute deal between Labour and the Liberals, the other hate speech elements and the migration changes have now passed Parliament. But this deal, as you know, also led to the fracturing of the coalition, with the Nationals crossing the floor and voting with us against the hate speech bill. Our legal experts here tonight will take you through the ins and outs of the laws, but I'll just highlight a couple of things. The proscription of hate groups is one of the most terrifying parts of the legislation. And we have seen in the UK already the danger and absurdity of misuse of proscription and terrorism laws.
It's just
Thousands
started.
of people arrested for engaging in peaceful demonstrations against genocide and in support of Palestine action. And constitutional expert Anne Twomey has raised countless issues with these laws. One of the concerning aspects she highlights is that a crime does not even need to be committed for a group to be prescribed as a hate group. And this is even before the migration changes, which scapegoat migrants and give concerningly broad powers, ministerial powers, without any procedural fairness. I mean, there is no other way to say it. By passing this legislation, the Albanese government has thrown protesters, and ones who speak out against human rights abuses, Muslims and migrants under the bus. And in the context of One Nation's racist rhetoric, its rise, and the Nationals and Liberals lurch to the right, I have to say that I'm very worried about what's to come. I guess the bottom line is this: we cannot criminalize our way out of hate and racism. Expanding the carceral system does not keep people safe. We know that this system is used against First Nations people. We know how the system has been used against activists and protesters. And we know exactly who this for the last 12 months. They can fund it and they can start implementing it. And I'll end by saying this. We need to be ready for what is coming. We will see a crackdown on Palestine solidarity, on the criticism of Israel. We will see more scapegoating of migrants. Even the government itself doesn't know the consequences of these laws, and that should terrify us. The way these laws can be used by current and future governments should send chills down our spines. But that only means that we have to be ready, prepared, armed with knowledge of what could happen, knowing full well that we will not stop speaking out and standing up against human rights abuses.
Thanks so much, Mehreen. That political context is so important for our understanding of what's happened. We'll now turn to one of our legal experts, Greg Burns, SC from the Australian Lawyers Alliance, whose analysis of the bill on the day it landed was invaluable. Can you please explain to us how these laws are going to operate?
Right, I think I'm unmuted now.
We can
You
hear
can hear
you.
me. Excellent,
Go ahead.
great. All right, so I'm Greg Barnes, SC. I'm a senior counsel barrister. I practice from Hobart. I'm in Nipaluna, on Nipaluna land today, on ceded land. As Amanda said, particularly relevant in the context of not only this week, but also this bill. What I thought I would most usefully do would be to answer questions, but also just to highlight some of the factors in this bill which make it difficult. And David, of course, has extensive legal experience, and he and I have talked about this. My colleague Tom Percy, KC from Perth, will join us if he can, but he's in a case because they're 3 hours behind over there. So he'll join us if he can, but I can certainly answer questions. So the Australian Lawyers Alliance, we've been very vocal about this bill. I think probably the most vocal of any of the legal groups, certainly the national groups, and for a very good reason. What this legislation does, and I see Tim Roberts here as well, who will equally understand this, is it creates concepts which are sort of foreign to the criminal law. They're foreign in the sense that they remove what we normally understand to be the way in which you define matters that legislation is prospective, not retrospective. They also, I do a lot of administrative law work, and what they do is to take away people's rights, what's called procedural fairness. But let me just go through some examples. So we don't have, and this is, I think, we need to be careful here. We don't actually have an offence which is called a hate crime. The government was going to introduce that and then backed away from it. What we do have is the creation of a concept of a hate crime for the purposes of prohibiting an organisation, calling it a hate group. So what the government can do is the minister who's responsible for the Australian Federal Police consults with ASIO and with the Attorney General, and essentially says that and then prepares a document for the Governor General, who can then make regulations to prohibit a group. But it's done on the basis of what's called reasonable grounds, that the group is engaged in conduct which constitutes a hate crime, and I'll come to that in a minute, or they've been associated with a hate crime by preparing, planning, assisting or advocating or engaging in such conduct. That's the initial trigger. And then the second trigger is that the minister has to be satisfied that banning the group is reasonably necessary to protect, and this is really broad, social, economic, psychological and physical harm. I've not seen that phraseology in legislation previously. Now, the difficulty is that, and whilst they have to consult ASIO, the regulation, the problem with the regulation is that it's a fairly low bar, reasonable grounds, without going into the court, without going into the law too broadly. Reasonable grounds is a relatively low threshold. What's disturbing is that the idea of a group, whilst the government says, oh, what we're after are these, organisations which are, fairly formal and they have, offices, etc. But that's not what the legislation says. It's the same problem. I came across the same problem in a big terrorism trial a number of years ago. It's the same problem with terrorism laws. You can get a group of people, an informal group, let's say, and I know, for example, after the Tampa and the terrible things that happened in the refugee space, there were a number of groups that just emerged. I spoke at a few of them. They were basically suburban groups. I did one in Adelaide where they were just a bunch of people who came together once every 3 months. They had a dinner and they get a speaker and they talk about how they could help refugees, particularly at Baxter. Now, is that an organisation? It's informal, but it's arguable that it's an organisation. And that's one of the great difficulties here of many. The second issue is that in relation to this is the secrecy aspect. So the minister does not have to accord procedural fairness. The general rule in law, and under what we call the rule of law, is that you have the right to be heard if your interests are going to be adversely affected. If they're going to take away your license, to run a shop, you're entitled to be heard. If you put in a planning application and somebody objects, that person's entitled to be heard. Here, there is no requirement for procedural fairness. That is really dangerous. And the reason it's really dangerous is, for obvious reasons, it leads to abuse of power by ministers. It was a favourite of Morrison and Dutton in the Migration Act to insert these clauses, and also in the Citizenship Act to say there's no procedural fairness required. So that's dangerous. It's also the minister, and no doubt ministers will say this, I've received advice from the Director General of ASIO, because they have to under the legislation, and the Director General recommends banning the group. And again, all the Director General has to be satisfied is that has engaged in activities likely to increase the risk. or advocated or engaged in violence, or there's a risk they might do so in the future. It's so broad. And again, of course, because it's ASIO advice, you never see it. We never see it. So, for those of us who practice on the light side of the law, the defence and against the state, this is very, very difficult. You've got to say to your clients, look, our hands are well and truly tied by this legislation. One of the other issues in relation to hate crime and also the ability to ban organisations, if the organisation advocates in conduct constituting a hate crime. And the legislation says this, I won't go through it all, but what it says is that basically an organisation will be advocating in conduct constituting a hate crime if it praises the engagement of conduct constituting the crime, provides instructions on how to engage in a hate crime, etc. But the minister can say, well, I've got to look at whether or not there's an unacceptable risk that such praise might have the effect of leading a person to engage in conduct. In other words, will it incite someone to go and do something? And it says, this, again, I've never seen this, when the minister is considering whether or not this advocacy has been a one-off or some rogue member of a group, or whether the group is engaging in this conduct, they've got to say, well, is there an unacceptable risk that this might incite people? And who's the person it might incite, regardless of the person's age or mental impairment? Now, I say this as a person who's acted for people with mental impairment constantly. But to say that the test should be whether or not, or that your evidence is simply that a couple of people who've got mental illness were fired up by what was said on the website of a particular organisation and have gone out and put slogans on buildings, is just bizarre. It's normally, there's an unacceptable risk that a reasonable person would go out and do something. I'll lastly say this about hate crime. And one of the problems is that the test has been changed. So it's normally the case that when it comes to discrimination in this area of law, discrimination or offences involving incitement, normally the test is what we call a reasonable person. Here, the reasonable person is the person who has the particular characteristic in respect of which the conduct is said to be directed. So I could get, and this is a point that Anne Toomey picks up, I could go to a rally, and at the rally, I say on a placard, Israel is an apartheid state, Israel is committing genocide. Is that an offence? Now, I don't know. I had calls last week from a couple of people about it, and I had to say to them, I'm not sure. What Anne Toomey has said is that she's not sure. She says, is it a hate crime under the Act to criticise the actions or policies of another country? Ordinarily, one would assume such criticism, which is political communication, would not be regarded as inciting hatred against a group because of their race, colour, ethnic or national origin. But, as she says, if you saw the Attorney General's appalling interview with David Spears last week on the 7:30 report, and dangerous, she said, oh, well, it might be an offence, because you would simply get a person who comes along, or you might get 4 or 5 people, go and make a statement. Members of the Australian community who are strongly supportive of Israel, they may be Jewish people, strongly supportive of Israel. That's not in itself problematic, but be strong supporters of genocide and be very hostile to Palestinians. They might well say to the police, look, I felt very uncomfortable about this. And I felt that, this was inciting hatred against me as a Jewish person. Um, it's a really dangerous piece of legislation. I'm happy to take questions on it, but what I can say to you is,
Thank you
unlike a
so
lot
much,
of
Greg. We've had loads of questions
yeah,
that are
so
going to
I'm going to
be
stop.
perfect
I'm
for
going to
your
stop there.
expertise at the
I'm
end.
going to
Yeah.
stop there. And
I
what
might
I am
wrap you
going to
up
say
now
to you
for
though
then so
is,
we can get through questions.
yeah. So I'm just going to simply say this: giving you definitive answers tonight is going to be difficult, but we'll try our best.
Thank you so much. We're really grateful for your expertise. I'm now going to throw to my colleague, Senator David Shoebridge, the Australian Greens spokesperson for Justice. David, can you tell us what the government and what the opposition have said about these laws and about the amendments that happen in Parliament as well?
Yeah, and thanks, Amanda, for emceeing. Thanks to Greg and Mehreen and Tim for being here today. Look, I'll start by acknowledging I'm on Gadigal land. I think many of us attended rallies yesterday in solidarity with First Nations peoples, where people were calling out the fact that this country has a history of genocide and continuing violence and institutional violence against First Nations peoples, criticising a nation, in this case, the nation of Australia. And if you're anxious about the extension of these laws, be very anxious, because actually criticising a nationality is one of the triggers for these laws, and making people psychologically unsafe because you're criticising a nation is one of the triggers for these laws. And many of us engaged in some frank and honest criticism of our nation yesterday. And I know there are a bunch of people who said they were offended by it. And of course, we have seen time after time where these kind of securitised laws are weaponised against First Nations peoples, and we should be mindful of that. I'm going to focus mainly on the prescription and the hate crime, the hate powers to prescribe organisations. But we should remember as well there were migration changes that were made with this legislation. As Mehreen pointed out, that was a form of scapegoating against migrants in response to an appalling attack that had no rational connection with our migration laws. The minister has been given new extended powers to cancel a visa of anyone who might commit a crime. That's pretty much anybody, an open slather for the minister to cancel anyone's visa at any time. There were provisions in there about cancelling visas for hate preachers. Every single immigration law expert we spoke to said they were totally unnecessary. There are already extensive powers to cancel that. It was purely done to dog whistle and to scapegoat migrants. Ugly politics, and we oppose them. But I might deal with the prescription powers. Now, Greg's touched upon it a bit, but I think probably that is the most concerning thing in these laws, giving, in this case, the Home Affairs Minister the power to ban groups, criminalise groups, and then criminalise membership of that group and see people potentially going into jail for between 5 and 15 years. And the bar is incredibly low. Grounds can include social, economic or psychological harm. And we've seen examples where we've had groups say that that individuals on campus, Jewish members on campus, have said that the mere presence of pro-Palestine events is causing psychological harm. Under this law, that would be a gateway to actually banning groups. And you can see that in the legislation. Protect the Australian community or part of the Australian community against social, economic, psychological and physical harm. That's an incredibly broad test. And of course, who is policing that test? Well, primarily ASIO. And of course, ASIO is not neutral in Australian politics. ASIO is only oversighted by the Labor Party and really the Liberal Party. No one else in Parliament really gets to see what ASIO is doing. Nobody else gets to direct ASIO's actions. It really can be weaponised by both the Labor Party and the Liberal Party when they're in power. They provide secret advice to the Home Affairs Minister, who then goes about criminalising groups and banning groups. And that will always be kept secret. And the reach of it includes not just people who are formally cashed up members of an organisation, but this concept of an informal member of an organisation. What's an informal member of the organisation? If you go to an organising group, if you attend a rally, what is it that switches from member to informal member? And if an organisation is in part organised by a group that's been recently banned, or members of a group that's been recently banned, and you attend it, do you become an informal member of that group and potentially go to jail? We don't know because there's no definition of informal member. The definition of advocates too. Groups can be banned if they advocate or promote, if they promote hate. Now, promote has been said to have a hugely broad reach. We've had constitutional lawyers say that it's much more than incite or direct or encourage. Promote can be creating an environment within which other people may engage in hate. And the other people who may engage in hate, as Greg pointed out, you could find yourself part of an organisation that's criminalised because you are promoting an environment where there's criticism of Israel. And then somebody in the community who is incredibly fixated, may have psychosis, may have deep psychological disorder. They hear what you're saying, and if they could engage in a hate crime, then you could be criminalised as well. It's extraordinary that these laws found their way through Parliament. And then as part of the amendments that the Liberal Party said narrowed the scope, the Liberal Party managed to persuade the Labor Party altogether to massively expand the type of conduct that can be covered by these hate crimes to include 7 different state and territory laws which deal with hate crimes. That massively, again, expands the reach of these laws. And you can find your organisation being criminalised and banned because it engaged in severe ridicule, like severe ridicule of Benjamin Netanyahu, severe ridicule of evil people, of Donald Trump for his appalling behaviour. Severe ridicule cannot be the test to see us criminalising groups and putting people in jail. And of course, as Greg and others have pointed out, no procedural fairness. The first you will know is likely when you get a knock on the door from the AFP saying your organisation has been criminalised. If you don't disband it, if you don't walk away from it, we're going to put you in jail. That's the first you'll hear about it. And rather remarkably, a bunch of the state and territory laws that are being used to prescribe organisations have defences in them. And you'll never be able to run that defence because they're never going to ask you, they're never going to talk to you, they're just going to criminalise you. So the honest truth is that in preparation for this, trying to find the answers about the reach of this, senior counsels we talk to, senior barristers we talk to, lawyers who specialise in this, say the reach is so incredibly broad, so ill-conceived, that they can't really put a boundary on it. But what I can tell you is this: we can't let this stop us organising for Palestine. We can't let this stop us organising for international solidarity, and we can't let this silence us. And I think that's a commitment that I'm going to give you as one of your Green senators, and I know it's a commitment that millions of Australians are going to give to.
Thanks so much, David, for your really important work cutting through that quite extraordinary spin from both the Labor and the Liberal parties on what's happened. We're now going to go to Timothy Roberts, the President of the New South Wales Council for Civil Liberties. As a State Greens MP in New South Wales, we've had the pleasure of working with the New South Wales Council for Civil Liberties in the context of Chris Minns's really draconian anti-protest laws. And I think building quite beautifully from where David finished, Tim, can you talk to us about the operation of these laws in the context of protest? If the Zoom fairies could please help us unmute Tim. Sorry, it's just taking us a couple of seconds to unmute him. I'm not going to pretend to fill in for his expertise on this issue.
Thank you very much. I have been unmuted. I've been released from silence. Trying to silence a civil libertarian in a Greens meeting. I would never have heard of this sort. I just want to congratulate all of the previous speakers. Once again, I find myself at the end of a list of my betters, and everyone here has spoken to essentially what I wanted to cover. Greg has gone through some considerable detail, which I'm very thankful for, but also has denied us the opportunity of seeing his, suppressed rage at press conferences and giving some feedback. So I want to thank Greg for his work on that, and David and Mehreen as well. So thank you very much, and thank you for the Greens for once again taking a very principled position on this. I guess some of the details, the breadth, a bit of the scariness about this has already been touched on. What I would like to just say is, I guess, what we need to be very vigilant about in terms of how this could be weaponized against movements like the Palestinian solidarity movement, and then just speak to what we can do going forward. And I think the word that comes to mind is vigilance. We have such breadth around what can be designated a hate group, such discretion, such blurred lines. I think when we have both, well, at least the New South Wales Premier and some rhetoric from the Federal Labor Party as well, that's speaking to copying and emulating the Labor Party in England, in London, the thing that comes to my mind is making sure the hate speech groups that are allocated and designated don't expand to groups that we know are peaceful and not hateful ones. And for instance, Palestinian Action Group as well. There's been a deliberate attempt to water down from terrorist and violence to hate group. And it's quite clear that I think that's giving some scope for a broader range of groups to be captured. I know there was a question about what this might mean for the climate, movement as well. Because these laws are directed towards racial vilification to a certain extent, but because of the breadth about who's organising that event, who's attending the rallies, who could be then associated with the groups that are attending, it's just too fuzzy. So it really is a law that has applications to, I think, all movements. And generally, what I'm seeing in the community is a real lack of understanding about our democratic rights and where their sources are. And we see in New South Wales a Premier that was using some very regressive rhetoric about the New South Wales government or other governments being the ones who get to dictate when people can and can't have free speech. It's a fundamental misunderstanding. So, in a very basic, maybe simplistic and naive way, it's about having conversations with your loved ones about our democratic rights. But for us, I think in our activist groups, it's about being vigilant about the expansion of these laws and acting in it. And let's be very real here. There's a risk that these laws are so bad, so encroaching upon our liberties, that the hate groups that are being named, and I have a particular concern about the Nazi Party, might challenge them and win. And a government has given a hate group an absolute win at a federal level about their laws. So we've got to watch this space. The short answer to the question is yes, these laws can be weaponized. I think we keep up the pressure about how poorly they are being used, so that we can get them turned around, or at least the minister who has so much power doesn't use them. At a state level, coming back down to New South Wales, what we need to be very careful about, and some people have been speaking to it in the comments, is the Premier has made it very clear he's not done yet about his protest laws, his hate speech laws, and seems to have some understanding, a mistaken understanding, that he has a mandate to proceed with further regressive legislation. So I think at a more local activist level in New South Wales, at least, I'm sure it's the same for Victoria, we've got a Premier that's not done. We need to be getting out and really pushing these points when we can. But we need to be careful about how we do that as a community, as an activist community, because unless we are vigilant about who's organising, who's leading these groups, I think we have a police force at a federal level who will use them to suppress those associations and those events. So we're going to be on the watch, and I think we just need to be very mindful about being strategic about the material we're putting out of these events as well. I don't put it any higher than that, because the chilling effect that comes with these laws, we don't want to give more permission to in expanding how we behave. Yes, you need to be careful. These are retrospective, dangerous laws. They could have implications if you get caught up on them, and they're so broad and it's such a big net that you might get caught up on them, and we can attend to it at the time. But that, I think, because of the way the government has designed these laws, shouldn't be what stops us from using our democratic rights. And let's be real here, and this is our thanks to the Palestinian activist communities, the solidarity movement. If it wasn't for them testing these governments at this time, we wouldn't be exposing the incredibly regressive approach of the Labor Party at a federal and state level. And I think that's an important thing that they've done. That just unfortunately means this work may not be finished, and we have to continue to do it. So let's be alert, but not alarmed. And my thanks to both the Greens and those activists out there that have been pushing these boundaries, and in doing so, protecting our rights as well.
Thanks so much, Tim. We've received more excellent questions than we possibly have time to get through in 20 minutes. We're going to do our best to get as many of those questions through to the panel as we can, and apologies in advance if I'm shortening your question. It's just so that we can get through more questions. So I'll start with one to Greg Barnes. This question's from Margaret Pistorius. She's asked, I have a question about what we might do to test the laws. How can we do that collectively and deliberately? What are the key phrases or statements that we will want to continue to make? And what are key statements that we would never want to give up making?
Well, it's a huge question. It comes to Tim's point of the difficulty in answering. I mean, how do you test the laws? Laws, like this get tested generally if, for example, someone was charged, if there was an application in relation to an organisation to prescribe it, if you were carrying symbols that are regarded as hate symbols. They're the ways in which legislation generally gets tested. Courts don't give advisory opinions. In relation to what you can and can't say, the difficulty I've got in answering that question is, picking up the point that David and Tim have made, which is I couldn't confidently say to you that that's okay. I mean, Israel is committing genocide is, in my view, a factual statement. Does it, though, run into problems as a consequence of this legislation? Potentially. I would have thought a court, and I think we just should say something about the courts. The courts in New South Wales, and Tim and David are more across this than me, have certainly pushed back against executive overreach when it's come to trying to ban marches. The federal court has a long tradition of being robust in the way in which it deals with executive government. And so I think, there will be some early challenges and they may be successful. The last thing I'd say is this. In relation to prohibited hate symbols, again, the difficulty with that is one of the features of it is that it reverses the onus. But secondly, it gives this bizarre defence, but it's so limited. Your defence is, if you've got one of these symbols, your defence is that you're either a professional journalist or you're doing academic research, educational, artistic, literary purpose, and it's not contrary to the public interest. Go figure. So in terms of what you can and can't say, I think it's extremely difficult to answer. What I am hoping is that, there is going to be a sort of network of lawyers created around Australia to try and put some collective energy into saying what we think the limits are. So watch this space on that.
Thanks so much, Greg. We've got an anonymous question that I might put to David. And the question is about the impact of this bill for First Nations Australians. Does it actually provide any more protections from them against racism?
Well, it does potentially, because they are could be identified by race or nationality. Therefore, there is a potential to protect First Nations peoples if hate crimes are directed against them. And we've seen groups like neo-Nazis and others directed. I think the experience we get when we're talking with advocates and leaders within the First Nations community is that they're not looking to the law to protect them most of the time. Most of the time, the law is actually targeting them rather than protecting them. And even a neutrally drawn law is often weaponised against First Nations peoples. And I don't know if people have watched in the last 24 hours, the Daily Telegraph and other Murdoch papers actually running attacks against First Nations peoples because they're out actively saying, well, White Australia is harming us, White Australia is causing us a genocide, White Australia needs to learn a lesson about this sort of stuff. And those kinds of statements from First Nations peoples are far more likely to be weaponised against them than hateful comments being made against First Nations being targeted to protect First Nations peoples.
Thanks, David. I'll go to a question that's been submitted by Abdullah, and I might put this question to Mehreen. The question is, we've seen a larger surge in anti-Arab racism and Islamophobia over the past few months than ever before. Despite the community pleading loudly with the government, there's almost no meaningful action taken. What does this mean for Islamophobia, and where do we go from here?
Thanks. Thanks, Amanda, and thanks, Abdullah. Yeah, well, Islamophobia has been rising not just over the past few months, but over years. And, we've heard the dangers of this bill, the risks and threats it creates. But also, it's very clear that it protects, with all its dangers and threats and risks, it only protects some people. And obviously, Muslims are not included in that. So I guess my experience living in this country has been as a Muslim that we have been treated as second rate. Even when the consultation on this bill was happening, the only organization that did not actually get to see the bill was the Australian National Imams Council. Other other religious organizations and other community organizations were shown the bill. I guess my biggest issue is how this creates a hierarchy of racism and hate. And that is never, ever going to solve the problems of so-called social cohesion in our country. There is a really well-researched, roadmap on how to make this country anti-racist, which is the National Anti-Racism Framework, which the government hasn't funded or implemented or even responded to for 12 months. So as a starting point, and I've been pushing for it, the Greens have been pushing for it for a long time, we need to make sure that that framework, which is grounded in justice for First Nations, is funded and implemented. I think that's one way to start seeing some change in how to tackle racism in this country.
Thanks so much, Mehreen. I've got a question from Caroline Lecouture, which I might put to Tim. What does this mean for protests to do with climate change? Tim's on mute again. I'm sure it's not personal. Here we go.
No trust whatsoever. Fair enough, though. I've obviously spoken too long. I tried to touch on this a little bit when I spoke. I think, look, it is directed towards racial issues, but we've got to be very careful because the way that the breadth about what makes up a group, who's a participant of it, what is a hate crime, which expands into you're taking up New South Wales laws. I'm concerned about the state government expanding their laws that might capture more and more of this stuff to be caught up in the laws. Minns has been explicit about saying that he would look to what happens in the federal level, to what he's going to be passing here. So let's watch out. But yeah, absolutely. These laws are so vague and so broad. It just really does leave a lot of room for us to capturing other things. So if we have hate speech directed towards, I don't know, Trump or American, fossil fuel companies and the like, and then that gets brought in, US-based sort of language. That's a real worry, and I really hope that we don't get there. But as has been said ad nauseum, I think a bit, we just got to be very, very vigilant here because it's so broad and so vague. It may just be caught up in this stuff.
Thanks, Tim. I'm going to put a question from Rowena to Greg, and I think a lot of people working on different causes might have a similar question in mind. Rowena says, our local Greens branch in Queensland is planning to host a public film viewing of a pro-Palestine film, including a Q&A afterward. What steps do we need to take now to protect our volunteer organisers and the community in organising this event now that the bill is passed?
Well, I had to say this, you shouldn't have to do this, but you might want to get it, as they say in defamation, legaled. I don't know if the group has got any lawyers or access to lawyers, but I think you've got to be cautious. I don't see any problem with showing a Palestinian film if it's, unless there's some prohibition attached to it through censorship, through, the board that deals with those matters. But if there's a Q&A afterwards, again, there's a possible risk depending on what's said and who's in the audience. And I think some guidance needs to be given. And that's what I think is important for lawyers around Australia to try and work up, and this is happening as we speak, work up some guidelines for people. I mean, this is uncharted territory. This is not like the anti-terror laws, which were much more specific. I'm for example, if you had a part of your Q&A, someone says, what do you think of the comment the Australian Jewish Association about X, Y, and Z, and you, as the person answering it, ripped into the AJA. I mean, it's a right-wing group, and ripped into them, ripped into their attitudes, etc. Is that going to be, Jewish people going to be intimidated, fear harassment or violence? I mean, who knows? So I think, to answer your question, try and let, as I say, it's incumbent upon the legal profession to try and work up some best advice that can be relied on, at least to give you some guidance. And I can say in Queensland, there are some very good people like Stephen Keim SC, who's did the Mohammed Hanif case. He's a great guy, and I'm sure he and members of, I don't want to dob him in, he's not here, but he and members of his chambers, I'm happy to put you in touch with them if you need them.
Thanks, Greg. Look, absolutely chilling that we might be in a world where volunteer organisers of a community film night might need to engage a lawyer. World we're living in.
Exactly right. Exactly right.
I've got a question from Faye Voyatsis. I might put this one to David. Contemplating what only can be described as a failed terrorist attack at the Invasion Day protests in WA. Are there any conversations about pushing the Royal Commission to cover all forms of racism, and especially the rise of right-wing radicalism in our nation, and faces that must be labelled as the cause of this horrific incident?
Yeah, a really good question. I think when you first read of the terms of reference for the Federal Royal Commission, it is incredibly focused on anti-Semitism and addressing anti-Semitism. But I think if you have a closer read of it, it actually allows the Royal Commission to go and have a look at other forms of extremism, other religions that need to be protected. And it kind of gives the nod to the Commissioner, Virginia Bell, if the evidence is before her, to actually go down and have a look at some of those other obvious threats against First Nations peoples, threats against the Muslim community. I think Virginia Bell is a woman of enormous integrity, and I think she really does stand out as someone for integrity. My hope is she'll be guided by the evidence, and I think the evidence will, as Mehreen points out, show that there are many groups, First Nations groups, Muslim Australians and others, the LGBTIQ community, who desperately need additional protections.
Thanks, David. I've got a question from Victoria Mason. It's to do with universities. I might put this to Mehreen because I know you're doing a lot of work on university governance as well at the moment. Victoria says, I'm an academic who works on Palestinian human rights. I'm also part of Academics for Palestine. What impact might this legislation have for scholars who research and teach on human rights issues, especially on abuses against Palestinians? And now Mehreen's the one who's been muted.
Thank you. And thanks, Victoria, for that question. I mean, I think as Greg said earlier in the response to one of the questions, this is really uncharted territory. But what I am more worried in terms of academics is the wholesale adoption by the government of the plan that was prepared by the anti-Semitism envoy. That is really like scary stuff. It is overreach. It is massive intervention into universities. I guess the first thing is the adoption of the IHRA definition, which conflates criticism of Israel with anti-Semitism. That, I think, is going to be what is going to crack down on, freedom of, I guess, the academics in universities. But also it has some extremely punitive and dangerous recommendations about cutting funding from universities and, also reviewing campus protest policies, which are already pretty draconian. So I think that plan has serious, serious implications for how our universities operate, how our students can protest, how academics can have the freedom to write and talk about human rights abuses, not just by Israel and Palestine, but anywhere else in the world as well.
Thanks, Mehreen. We've got a couple of last questions. I'm trying to squeeze in as many as we can. I might put this one to David. There's a question from Nico, asks, could the legislation be used to prevent boycott campaigns? So, for example, against Israeli dates produced in illegal settlements?
Well, absolutely. I mean, you just have to cast your mind back to some of the incredibly brave campaigning, anti-apartheid campaigning, which actually pointed out the South African regime was hateful and racist and engaging in hateful, racist, violent policies on the ground. One of the core campaigns there was a boycott of South Africa, and it ended up being successful. But at the time, there were Australian politicians, there were members of the Australian community who said it was appalling, it was a form of discrimination against South Africa. How could they possibly do this? Just rub out anti-apartheid in South Africa and put in Palestine, and you realise the breadth of this law. It's designed to be able to be weaponised against people who are causing economic harm, against a part of the Australian community identified by their nationality. They could be people who have business ties with Israel and are tied to that. And if we boycott that, well, it's absolutely, I think, it's ready, locked and loaded to be done against people who are campaigning for economic boycott.
Thanks, David. I'll put one last question to both Mehreen and yourself. You were obviously behind the scenes at the table in some pretty intense negotiations in the federal parliament. The question was anonymous. The question is, was there any world that these laws could have been made viable? Yesterday, I understand we saw a neo-Nazi get arrested under these laws, which I think many of us would agree is a good outcome. Was there any world where the Greens could have negotiated with Labor to make the laws viable?
I'll let you go first when we get you unmuted, Mehreen.
Yes. So as far as I understand, the neo-Nazi that was arrested was under New South Wales laws, which were passed early last year. I guess from our perspective, like we looked at these laws as thoroughly as we could in the time that we had been provided, and it did become very clear that with the number of red flags, there was no amount of amendments that could fix these laws. And really, why would you want to start from backwards, trying to improve a horrible, horrible bill? So that was off the cards pretty quickly for us. And I keep repeating, I guess, we really have to think about whether criminalizing is the way to deal with hate and racism. I am very strongly of the view that it is not. This is a cultural, societal change that is needed. And the carceral system isn't there to make those changes. We have to deal with it by grassroots, funding community groups, that sort of thing. And the 63 recommendations, I keep repeating myself in the National Anti-Racism Framework, after 5 years of in-depth consulting with the community, has things from mandatory anti-racism training for, politicians and their staff, to introducing a Human Rights Act in Parliament, and everything in between.
Yeah, absolutely, Mehreen. Of course, there are limits in any free society, I think, to what is acceptable in terms of speech. Inciting violence against another group, calling for violence against another group, that's where there is a role for the criminal law. If people are encouraging people to actually engage in violence, of course, there is a role for the criminal law in those spaces. But the idea that criminalising a broad amount of speech in the way that is being proposed here is the way we address hate. I think that is not the role for the criminal justice system, and never has been the role for the criminal justice system. We were given this legislation really late on, just last Tuesday. It seems longer, doesn't it, Mehreen? But just last Tuesday, we were given over 140 pages of legislation, 300 pages of explanatory memorandum, and we did our best to get our head around it as soon as possible. But as Mehreen has pointed out, the legislation started from a deliberately, intentionally discriminatory basis, designed to protect only one religion and throw other religions like Islam and Hinduism, other religions, throw them under the bus. And when legislation starts from a deeply discriminatory starting point, we soon found out that there was no way that we could amend this to a shape that would respect the kind of diversity in society, or produce legislation that met a kind of basic fairness test in how it could be applied. But it was incredibly complex legislation. We did our job as legislators by trying to get a head around it. I want to thank people like Tim and Greg and others who helped us get a really rapid assessment of incredibly complex, and it turned out, incredibly dangerous laws in less than a week. And that's never how we should be making legislation in this country, particularly around something that is so potentially divisive in our society.
Thanks so much to both of you. I'm sure I'm not the only person very grateful that you were both at the table during this really critical debate and negotiation. Folks, we've received over 100 questions. We are not going to be able to ask all your questions. So I apologize if yours has not been asked. It's not because we haven't got it. It's because there's been so much interest in this issue. The organisers have told me that we're going to see what we can do to respond to more in a different format, and we'll let you know as a follow-up to the event tonight. But we are going to try and stick to an hour and wrap this up shortly. In conclusion, to each of our panelists tonight, I was going to offer you 1 minute just for any concluding thoughts, and in particular, where do we go from here? What's next?
I'm going to give you I'm going to do some incitement. I'm joking. An old colleague of mine in Melbourne who was in the anti-Vietnam War demos decided last week that he didn't understand the bill, so he sent an email to Michelle Rowland's office, and he's a very experienced lawyer with a series of questions. I don't think he's got an answer. But look, and I mean this seriously, you should be, if you have doubts, you should be asking the Attorney General and the Minister for Home Affairs what these things. But you won't get any meaningful response. But the government needs to understand, and the opposition needs to understand, that this legislation is appalling. Not only in terms of its content, it's as David and I've been talking, it's unintelligible. So if you want to politely go to your local MP, ask them the questions, talk about the problems with the legislation, because it is time now to let them know just how bad it is. But I'll emphasise, of course, the best way to do it is politely but firmly, and make your points.
Thanks, Greg. We might go to Mehreen next.
Yeah, thanks, Amanda. I mean, I know after this webinar today, many of you will be rightly feeling nervous about what's to come. I mean, in every social movement, there comes a time of extreme repression, and I think this could be it for us. For me, I'm resolute in the fact that we cannot back down. Like we have seen people power in marching across the harbour bridge. We made headlines worldwide, and we forced the Albanese government to acknowledge Palestinian statehood. So we must continue to stand together for our brothers and sisters in Palestine and all injustices around the world. If they want to silence us, we will be louder. If they want to break us, we will be stronger. That's my promise to you.
Thanks, Mehreen. We might go to Tim next.
Absolutely, here, Mehreen. I think if I was to be positive, maybe a bit of a dreamer, Human Rights Act, both federal and state level. There are two really successful campaigns that are going on. One run by the Human Rights Law Committee Centre at a federal level, and Human Rights in New South Wales, which CCL is a co-convener with the Australian Lawyers for Human Rights. It's Labor Party policy to have one. They're not controversial in any way, these laws. They get us on the front foot, and both acts speak to a process in which, when bills are being introduced, there would be flags about what human rights there can be in being issued. It doesn't prevent them from being issued, but it makes explicit the problems here. And it slows things down, quite frankly. So we haven't got responsible government, and a Human Rights Act at both the federal and state level is a great way to get some responsibility into this situation. It's not a fix. It's not a be-all and end-all. We may not get the act that we want, but it's a great place to start. And you can contact your MP and ask them, have they met with the organisers of those committees, because they understand that those committees have sought their invitation. They want to make sure that they've met with them, because I can tell you, we've asked them all, and not everyone said yes. So guilt them if you can.
Thanks, Tim. David.
Yeah, look, we can't let people be isolated and picked off one by one. I'm sure the government will first come out and ban some truly hateful groups, but then they're going to start coming, when they start coming after our friends and after our allies. We need to be there with them and not leave them be isolated. If there's crowdfunding, we jump into the crowdfunding. I ask our lawyer friends to wrap around and throw every possible legal and constitutional challenge to protect our friends and never leave them isolated. Of course, bad laws can be put on the statute books, and bad laws can be scrubbed off the statute books as well. And we need to make that a goal of the campaign, to repeal these laws and to remove that chilling effect on broad society. How do we do that? Well, we need to get rid of the duopoly, the warmongering, genocide-denying duopoly that seemed to have this sort of stranglehold on federal parliament. And that means organising electorally. That means organising socially. That means making sure that we have hundreds of thousands of people marching in our streets, marching across the country for the kind of society that stands up for international law, that doesn't engage in genocide denial, and that sees international solidarity as the way forward for countries like Australia. So, there are so many campaigns to be part of this as well. Linking those campaigns together, I think, is absolutely critical. But I really want to thank everyone for coming tonight, for getting informed. I really want to thank Greg and Tim and Mehreen. I feel much better informed sitting here and listening from all of you. And Amanda, thanks so much for volunteering to do the emceeing, and thanks for the work you're doing in state parliament to fight against Crispian's anti-protest laws. Really appreciate that too.
My goodness, what an incredible panel. I'm certainly feeling more informed and more hopeful than I was an hour ago. Thank you as well to Kim and Lauren behind the scenes wrangling a truly enormous Zoom meeting. And I wanted to say thank you to all of you in the audience tonight. We've had just extraordinary engagement in the chat and engagement in the questions. Honestly, overwhelming engagement. Too many questions to possibly put. But it's given me so much hope to be able to connect with you all tonight. And I think particularly seeing that solidarity across different movements. We had questions and discussion tonight, of course, about the pro-Palestine movement, but the connection to First Nations justice, to climate justice, whether it's LGBTQI plus justice or disability justice, really that solidarity and all of us coming together is the only way that we can defeat bad laws like this. And it's really filled my cup to be a part of this event tonight and to see this really important, critical engagement from all of you. I'm sure this won't be the end of the conversation, and there'll be some follow-up to everyone who's registered tonight by email. So thank you so much for coming. Thanks to the organisers. Thank you so much for David and Mehreen for bringing us all together tonight, and thank you all for being a part of it.